Hello and welcome everyone to the Polity Primer series of Drishti IAS English. My name is Pragya. In today's episode of Polity Primer, we have to discuss yet another important and significant constitutional amendment. The title of our today's discussion is the 104th Constitutional Amendment Act of 2019. So in this discussion, we are firstly going to study about what is the 104th Constitutional Amendment. Then we'll also examine what led to the 104th Constitutional Amendment. Why was the Parliament so keen to enact this 104th Constitutional Amendment? Then we are also going to examine the constitutional changes that have been introduced in our Indian Constitution through this amendment. And lastly, we are going to discuss some of the important questions from the perspective of your prelims examination. So if I talk about the background of our today's topic, so the Constitution Bench of the Honorable Supreme Court of India has recently agreed to examine the constitutional validity of the 104th Constitutional Amendment Act, and the case is titled as in Re Article 334 of our Indian Constitution. Okay, so this is the case title, in Re Article 334 of the Constitution. So basically the Supreme Court in the initial observation has said that they would be examining the constitutional validity only to the extent that it has prolonged the reservations that are given to the SC and ST community. As far as the reservations for the Anglo Indian community is concerned, it has ended finally after 70 years. So the petitioners in this case are arguing that firstly, this 104th Constitutional Amendment Act is unconstitutional in nature, majorly on two grounds. Firstly, the violation of basic structure, because it gives immense power to the Indian Parliament to keep on prolonging the reservations. Okay, they extend it another for a period of 10 years again and again and again and again by bringing amendments in our Indian Constitution. They are also arguing that yes, it is also against Article 14 of our Indian Constitution, which gives us the right to equality, and the Supreme Court has agreed to examine the validity of this Constitutional Amendment Act. So this brings us to the moot point of our today's discussion, that what exactly is the 104th Constitutional Amendment Act. So if I talk about the 104th Constitutional Amendment Act, it has made two major changes. Firstly, it has ended the reservation for the Anglo Indian community. Anglo Indian community. So we have studied and we all know that they are entitled to the reservation by virtue of Article 331 and Article 333 of our Indian Constitution. Okay, so they are entitled to reservations in the House of the People as well as in the state legislatures. Okay, state legislative assemblies, they were entitled for the reservations. They were entitled to the representation, and that is why the President had the power to nominate two persons from the Anglo Indian community to the Lok Sabha. But this reservation has been ended by the 104th Constitutional Amendment Act. Secondly, it has also prolonged the reservation for the scheduled caste and scheduled tribes for a period up to further 10 years. The original reservation that was given by the Constitution to the SC/ST community was only for the period of 10 years, but it kept on prolonging. Okay, and the last reservation ended in the year 2000, that was 2020, that was given to them by the 95th Constitutional Amendment Act. So this Amendment Act further increases the reservation period to the year 2030. Okay, as we all know, Article 330 and Section 3 of the RPA Act 1951 provides for the reservation of the SC and ST community in the House of the People as well, in the state legislatures as well as in the local and urban bodies. Okay, so they have their own constituency dedicated to them. Okay, although the voters are from the all the castes. Okay, but the candidate should be from the SC and ST community. Okay, and this has been mandated by Article 330 of our Indian Constitution as well as Section 3 of the Representation of the People's Act 1951, which allows the division of the territorial constituencies for them based on their populations. Okay, moving forward, let us discuss Article 334 of our Indian Constitution, that is primarily challenged before the Honorable Supreme Court of India in the case. Okay, so Article 334 of the Indian Constitution deals with the time period to cease reserving seats for the SC/ST community and the Anglo Indians. So as I have mentioned that when our constitution came into force, the reservations were only for the period of 10 years. Because our founding fathers were cognizant of this fact that yes, they were not represented properly. There was caste-based discrimination against them. They were marginalized in India. And that is why, to give them adequate representation, not only in the House of the People, not only in the State Legislative Assembly, but after the 73rd and the 74th Constitutional Amendment Act, they are also entitled to this reservation in the urban and local bodies. Okay, and this was envisioned for the initial period of 10 years. But the Parliament, by making constitutional amendments over the years, has extended this reservation every decade. That is, every 10 years they extend this reservation that has been given to the SC and the ST community. Moving forward, let us discuss what led to the 104th Constitutional Amendment. So basically, the 8th Constitutional Amendment for the very first time extended the reservation period to 10 years. Okay, it extended the initial reservation period of 10 years to further 10 years. Okay, then came the 23rd Amendment, 45th Amendment, 62nd Amendment, 79th Amendment and 95th Amendment, and all of these amendments had only one purpose to solve, and that is the prolongment of the reservation that is given to the SC and ST community by 10 years. Now moving forward, let us understand the constitutional changes that have been brought in the Indian Constitution through the 104th Constitutional Amendment Act. So basically, as I said that yes, the Anglo Indian community was entitled for reservation. Okay, and in India, the representation of the Anglo Indians in the Lok Sabha of the Indian Parliament was very unique in nature, with only this community having reserved seats. And what is the Anglo Indian community? Basically, they are the offsprings that are born to the British father and Indian mother. So when the Britishers were ruling over us, okay, they wanted the British officials to marry the local Indian women, and that is why the offsprings are known as Anglo Indians. Anglo Indians. And this is a minority community in India. So after independence also we considered giving reservation or representation to them in the House of the People. Okay. The concept of reservation for Anglo Indians can be attributed to Frank Anthony, who served as the president of the All India Anglo Indian Association. Moving forward, as I have mentioned that Article 331 and Article 333 of the Indian Constitution permitted the nomination of 2 Anglo Indian community members to the House of the People as well as in the state legislative assemblies. Okay, and they were nominated by the President of India and the Governor of the state respectively. Okay, however, this provision ended by the 104th Constitutional Amendment Act, and this is the major criticism of the 104th Constitutional Amendment Act, that it has taken into account the 2011 census, the figures of which the Parliament took into account, but the critics argue that these figures are not true. Okay, because census has not been again conducted and you have already ended the representation, and it is a minority community in India, so how could you infringe upon their rights by ending their reservation? So this is the major criticism of the 104th Constitutional Amendment Act. With this, we come to our conclusion of our today's discussion. We have discussed the 104th Constitutional Amendment Act. We have also understood that yes, there were predecessor amendments which increased the reservation for the SC and ST community, and the 104th Constitutional Amendment Act has further increased this reservation for the period of 10 years. We have also seen the major changes introduced by the 104th Constitutional Amendment Act in our Indian Constitution. Now let us discuss the previous practice question which I asked you in my previous session. So the question is, consider the following statements. So statement number 1 is, the Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. Your statement number 2 is, the Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. So which of the statements given above is are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. So your correct answer is going to be only 2, option B. Statement 2 only is correct, because our Indian Constitution nowhere defines the basic structure. Okay, this basic structure doctrine has been the evolution of the Honorable Supreme Court of India in the Keshwanand Bharti case. So if you ask that does Constitution define this word basic structure? No, it does not define it. Okay, and that is why your statement number 1 is not correct. This basic structure doctrine was originally evolved by the Indian Supreme Court. Now let us discuss the practice questions from our today's session. So the question is, consider the following statements. Your statement number 1 is, 104th Constitutional Amendment Act abolished the reservations for the Anglo Indian community. Your statement number 2 is, Article 331 of the Indian Constitution provides for the nomination of 2 Anglo Indians to the Lok Sabha. Which of the statements given above is are correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, and option D is none of the above. So your correct answer is going to be option C. Both of these statements are correct in nature. Moving forward, let us discuss the last question of our today's discussion. So the question is, consider the following statements. So statement number 1 is, Article 334 of the Constitution deals with the time period to cease reserving seats for the SC and STs and Anglo Indians. Your option 2 is, statement 2 is, the reservations were only for a period of 10 years initially. So which of these statements given above is are correct? Option A, 1 only, option B, 2 only, option C, both 1 and C, and option D is none of the above. And this answer will be given by you to me in the comment box below. I hope this session was insightful for you. If you have any feedback regarding this session, you can drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.